This is Bill White with RealLawyers.com. Let's look at a family law situation. Let's say we have a husband and wife who have a 7-year-old boy. The husband has a drug and alcohol problem. He's had several DUIs, and in front of the child, he often uses drugs and passes out. But the last straw for the mother occurs when the husband leaves the car running in the garage all night. So the wife, fearing for her son's safety, decides to pack up belongings and move with the child across the country to live with her mother. Can she do this? We asked one of Minnesota's top family law attorneys.
The answer is almost without exception, no. Because we have law that prevents people from unilaterally removing a child. It's basically similar to kidnapping. And if you have a situation, for example, you have a father who is chemically dependent, who puts the child at risk, lets the car run all night in the garage, gets a DUI, drives with the child, God forbid, when he's intoxicated, does other things that could be harmful to the child, doesn't watch the child because he's laying on the couch asleep from the alcohol or the drugs. What's going to happen there? Any reasonable person would realize that the law, the courts, are going to prevent that child from being at risk. That is the first thing that we try to do, is to protect children. The statute talks about what is in the best interest of a child. And what is in the best interest in this hypothetical we're talking about is that child not be subjected to risk, not be subjected to any inappropriate behavior by a parent. So it's not just in the hypothetical, it's other situations where you have a parent who's a bad parent, or not a great parent at least. So what a person should do if he or she needs to move out of the state is start an action, a legal action, go to court, present the evidence of why it would be in the child's best interest to move. And in the hypothetical, I think a court would say, well, clearly the child's at risk. At the very least, the court would say, dad is out. Dad would have restricted access, if any, to the child until dad gets well and stops relapsing. It's possible the court would let the person move, but they're kind of different reasons. If you have a child who's grown up in Minnesota, you could look at different ages, but clearly there have to be reasons why this child should be moved to another state, because it would be in the child's best interest. Well, if mom is here in Minnesota, mom's not employed, mom doesn't have any money, dad has this chemical problem or alcohol, whatever, mom can say, I had a job in the family business in Michigan, and I want to move back there because I'll have the job and I'll be able to support me and I'll be able to support our child. And I don't have that here. And the economy's bad, so I can't find a job. I've been looking for 6 months or a year. So that would be one example where a court might say, okay, plus the relatives are there, the family's there. But you look at both sides of that. If a child's here and his or her roots are here and friends and school and everything else, it's not easy to move a child out of this state or any other state unless you have some very strong evidence.